We can begin,
Teresa. Okay. Welcome to today's webinar, Technology, Ethics, and Estate Planning Practice Management, presented by Interactive Legal and Peak Trust Company. Today's presenters are Martin Schenkman, Jonathan Blottmacher, and Peter Fidler. We're going to dispense with long introductions, and I'll just turn the floor over to you now, Marty.
Thanks, Teresa. We're going to begin the program, and thank you, everybody, for joining us. If you have not downloaded the handouts, I'll quickly tell you what we have and where they are. On the taskbar, the navigation tool for the webinar, there's a tab called Handouts. Open it up, and you'll see 4 PDFs. The primary one, and you should probably just choose one if you haven't printed it if you'd like to. I've given you the PowerPoint in PDF format in 2 different styles depending what you like. One is 1 slide per page. So if you're old like me and need big print, you should print that one. For many others, I've given you 3 slides per page with a series of lines down the right column to take notes. There is also a series of handout materials that Peter Fidler, an IT consultant, has provided, and Peter will be commenting and discussing some of that perhaps throughout the program. And then there's a minor item called footer messages for bills, which I'll be talking about. And it's just an illustration of how I use my billing system as an off-label way of communicating to clients. Just one of the many ways you can adapt technology very cost efficiently to help in an estate planning practice. So let's just get started. And the format for today's program is I'm going to kind of introduce each topic and talk, and Jonathan Blottmacher, who's promised me, and I know this may be surprising for all of you who know him, he promised me he won't be shy on the program. And Peter Fidler will comment and offer different perspectives. Before we begin, let me just give a plug for Jonathan. Alaska Governor Bill Walker issued a press release yesterday acknowledging Jonathan as a force behind the vibrant trust and estates industry in Alaska, and personally thanking him for how he's contributed to the state's trust and estates industry. So congratulations, Jonathan.
Thank you, Marty.
And for any of you who didn't see it, it was, I think, just a press release. It was not tweeted. Now, one of the things we're not doing in the comments that Peter, Jonathan, and I are going to make, we're not setting up standards of practice. We're not saying that anything we're suggesting is more than merely a suggestion. I don't like when somebody speaks and the tone or intent of their comments could be interpreted to imply that this is something you have to do. So even if we say words to the effect of that, you really should think about using encrypted email, we're not setting any of this up as anything more than a mere suggestion. So I don't want to see anybody of our colleagues have their feet held to the fire over anything that we're suggesting. Slide 5. One of the things that I think is important, and I work with co-counsel all over the country on lots of client matters on a regular basis, and it amazes me how outdated so many of the engagement letters, even from many big firms, tend to be. I got one yesterday from a very substantial firm that had a date on it from 2013. It's not possible, in my view, that whatever you did in 2013 is what you need in an engagement or retainer agreement today. I think we should all try to regularly update our retainer agreements to address some of the changes in technology, and we're going to talk about some of those things here. I think it's important because it's a great way to communicate to clients how you practice and what they should expect. It's also a really important way, I think, to help protect the practitioner by letting people know how they practice and what they do. If you're storing documents in the cloud, my thought is I'd let them know in the engagement letter, the retainer agreement, so somebody can't later come back and say something. As another example, I have a comment in my engagement letter, retainer agreement that I have clients sign that we use unencrypted email for regular email. And that's frankly, I think, the standard of practice that most, if not almost all practitioners use unencrypted email for most communications. And we're going to talk about a recently issued ethics ruling but I think it's important to have clients acknowledge that. So retainer agreements can really be an important part of the practice management and communications to clients, and again, should be updated for technology. I just did an article. It hasn't been published yet, so I couldn't make it available on the webinar, so I apologize, with Sandy Glazer from Detroit on engagement letters that should be published in a upcoming issue of Trust and Estates magazine that will have some sample language and discussion of those points. Also, it's important to note there's great variability in practice. If a practice is largely paperless and cloud-based, the way you're going to take and adapt or use some of the comments that we're going to make is going to be very different than a practice that remains rooted in paper, red welds, and yellow pads. Jonathan, Peter, I, and another colleague, Mel Bergstein, gave a presentation for the New Jersey Bar on this topic a couple of months ago. And I was actually quite amazed that when I started the program, I asked how many people in the audience had paperless or near paperless offices, and only 1 out of about 75 people in the audience raised their hand. So it was myself and one very young practitioner in the back of the room that had paperless practices. I'm sure the numbers are higher generally, but again, I want to acknowledge that many people still may be rooted in paper, even if they do scan a lot. So again, how you're going to adapt some of our comments and suggestions will depend on the nature of your practice. Also, the type of practice you have is going to be very different than if you have a flat fee practice that does a high volume of documents for moderate wealth clients, or in the far end of the extreme have a boutique kind of practice that really focuses on ultra high net worth clients. We're going to try to make some comments and give you some practical tips on tech and ethics and so on and so forth for both ends of the spectrum.
Marty, this is Jonathan. Do you think it's more difficult for a larger firm to convert to a paperless office as opposed to, a single or dual practitioner law firm?
I don't know how to answer the question, because I really work as primarily as a solo practitioner, a very small practice. I can say that I'm always envious of the large firms when I collaborate with them, and they have in-house IT people and office managers and an incredible array of talented staff that seem to do things. So many of the things that I have to do when I adopt new technologies is try to figure out how to do them in a very time-efficient and cost-efficient manner, because I don't have the people or financial resources that a bigger firm does. So I think the answer is it's much easier for me to make a decision and do it, because I don't have 100 different partners feeling very differently and each having their own opinions and practice styles. But I also don't have the resources. So I think that it's a mixed bag. I think it just depends.
So this is Peter. In my experience, that it's a smaller firm is much more nimble and has a better capacity to make quick decisions, rather than a committee of 1 or 2, rather than a committee of 10 to 12. These technology committees in some of the larger firms often get bogged down in the nitty gritty. Nobody's going to find a 100% solution. So, and it's unfortunate, but a number of firms try to attain that. But in the larger firms, you're really trying to attain an 80% solution, and that's unacceptable to some of the larger firms.
Well, one of the interesting things that I've seen with some of the large firms that I work with is one firm, for example, and obviously I won't use names, is in their view paperless, and they've basically had everything in the entire practice scanned and dropped into a document management system. Several of the partners that I work with, even though the firm is quote unquote paperless, they basically have their administrative and secretarial staff print all the documents on every file, every matter they're working on, set up the same standard old red welds that they've always had. And if you walked in their office, it doesn't look any different today than it did before the firm was so-called paperless. So, sometimes when a firm makes a decision, it doesn't mean that they're really getting all the practitioners on board, the partners on board in terms of how they practice. I think the bottom line for all of it, and I personally have to, and I've never done this before, thank Jonathan for it, because many years ago at the Heckerling Institute, he gave a speech about the virtues of going paperless, and I think it was in maybe 2009 or sometime around then, and it was before really most firms had given a lot of thought to it, and I drank the Kool-Aid and jumped on board, full steam ahead, and in 2000 and I think 9 and 10 started scanning everything in my practice, and in 2011 returning all client documents to go completely paperless. And it's transformed how I practice. It's transformed, just as Jonathan predicted, the amount of office space I need, because we really don't have significant paper. It's transformed how I practice, the profitability of my practice, and frankly, it's transformed, and we'll talk more about it, how I work and how I practice and how I draft. Everything is different, and in my view, all for the better. It's enabled me to devote more time to clients, less time to dealing with paper, and less time dealing with administrative stuff. And part and parcel of that conversion process is using document generation software. We're going to talk about all of this as we get on in the course, but it's been a phenomenal change. In
Marty,
my conversion,
Marty, let me add another thing. When I made that lecture at Heckerling, it was towards the end of my active practice at Milbank Tweed, and I was never very effective in getting almost anything done in the modern mode, in part because older partners in those days wouldn't even do email, and I'm not exaggerating about it. But one of the great advantages of being paperless or close to paperless is that people can work from other areas. And as a consequence, if you can cut out, for example, someone having to commute into Manhattan from New Jersey or Connecticut or Long Island, you may be able to reduce the cost of hiring such people, because, you put in, no matter where you live in the New York area, you're talking about a minimum 2 hours and often 4 hours a day of a commute. And I know when I looked at the cost of hiring a secretary between Nassau County, where I live on Long Island, and Manhattan, secretaries in Manhattan were paid, same skill set, same kind of work being done. They were paid about 80% more than those out on Long Island because of the commuting and the lost time. Because, you sit on the train for 2 or 3 or 4 hours a day. That means when you by the hour, you've got to pay a lot more. So that's one of the advantages of really going paperless and allowing access that way. That in turn, Marty, raises the question, and it's an interesting one. If you have a lawyer who's admitted to the bar in New York, and she lives in New Jersey or Connecticut, and she's doing her work from her own, is she now engaging in the practice of law in a jurisdiction where she's not admitted, even though the law firm is in New York? And that's an interesting question. As far as I know, one that's not been resolved, but probably will come up sometime in the future.
It can actually go a little further. Jonathan and I were collaborating on a incredibly fascinating, I would think it's fair to say, cutting-edge estate planning matter that we're working on a few weeks ago. And when I was speaking to him, I was sitting in a gorgeous Airstream trailer along the banks of the Red River in North Dakota with a nice glass of wine. And you could not do that without the technology and the wireless systems and so on and so forth. Just another quick comment on paperless. When I define paperless, it's going to come up in a second, but let me see where it is. All right, we're going to come to it in a minute. But when I define paperless, I'm not paper-free. I'm paperless, very little paper. But there's a couple of things that we've continued to keep in paper where I felt that it was prudent to have certain things in paper. So, for example, one of the things that we do, and it's not in the materials, I apologize, but in my paper-less environment, we keep paper closing binders on large trust and client transactions. Because if a client that's done a major transaction or a complex note sale transaction calls, or their accountant calls, or their wealth manager calls, it's too hard, in my view, to go through a document management system and try to reconstruct what's going on and get my arms around the file. So for large transactions, we complete a closing binder. Everything's been scanned. We have it all paperless and electronic as well. But I find that if I get a phone call and need to get my arms around a file, it's very helpful to have schematics, summary memos, the actual trust instruments, transfer documents, all at hand in a binder organized. So we're paperless, but not completely paper-free, even though those things are scanned. One of the other things that I have found, I'm curious if other practitioners have found the same thing, we continue to draw by hand client family trees. I've tried and tinkered with all sorts of Microsoft Word notes, different family tree drawing software, but I just find that there's such incredible variability from family to family, and I don't even know if I would put the word family in quotes, that drawing family trees using software is just very hard to do. Let's move on. So one of the things that we all have to deal with as attorneys, RPC 1.4, lawyer has to fully inform a client of how, when, and where the client may communicate with the lawyer, and we should keep clients reasonably informed about the status of the matter and promptly comply with reasonable requests for information. Technology has transformed how we can do this and how we can meet not just this, but so many of our obligations. And we'll talk a little about that and try to give you some practical thoughts and tips on it. New Ethics Opinion 477 was really just recently issued. Note the third bullet point. Comment A to the rule requires lawyers to be current regarding benefits and risks associated with relevant technology. So I think it's critical for practitioners to interface with their IT consultants, unless they have in-house capabilities, to make sure that they understand what their ethical duties are and how the technology that they're working with affects that. We each have to take appropriate steps to minimize inadvertent or unauthorized disclosure of client information. And the phrase, and we're going to come to it on the next slide, reasonable efforts to ensure that communications with the clients are secure. Let's take a look at what that means. So you have to give consideration to the sensitivity of the information being transmitted, the risk of disclosure if additional security measures are not taken, the cost of additional measures, the difficulty of adding additional safeguards. There's a comment, I'm not quite sure how to interpret it, might additional safeguards adversely impact the lawyer's ability to represent the client? The problem is that hindsight's always 20/20. When does an issue like this comes up is when somebody says, gee, why did that get exposed? Why did that get disclosed? How did that get out there? It does say, and this is very important because I think it is the vast majority of lawyers practice this way, that you may use unencrypted email when communicating routinely with clients. Now, what does all this mean, and what should we do? Let me make a couple comments, and then perhaps Peter or Jonathan want to comment. I think email is routinely done, and I don't think that's going to change. What I'm trying to do in my practice, and I believe it is where things are moving, is we use a secure encrypted email. We use a system called ShareFile. It was a Citrix product, but I think it was recently bought out by the company that owns
It's still Citrix.
Oh, okay. Sorry about that. And we create a specific portal for each client that's secure to that client, and we can transmit documents through an encrypted email system to the client in that fashion. We try to send documents that have, for example, tax identification numbers, gift tax returns, and so on through the encrypted email. Now, the challenge with that, which is why it's very difficult, I would almost say impossible to really fully do that, is a lot of clients, especially some older ones, struggle with the system. Banks who we routinely collaborate with on client matters, trust companies, their firewalls prevent their accessing items posted through ShareFile. But I believe that the future is moving towards, or the standards of practice are moving in the direction of us all having to send key documents, especially those with tax ID numbers or sensitive financial information and tax returns, through encrypted email. And the accounting profession always seems to be ahead of the legal profession in doing that, and I think that's pretty much the norm for accounting. Peter, perhaps you want to comment on some of the things practitioners may want to look at in this regard.
Yeah, so obviously the ShareFile is a great solution for that. And when an attorney is emailing something, it goes out in plain text. So anything that goes from your server to their server it can be read by anybody. So if you have any hesitation of any confidential information, you should send it in encrypted. ShareFile is a great solution for that. There's a company called Mimecast that has an encryption package, and there are a number of other software packages. The difficulty is you want to sort of do it in the normal course of business. If you want to send an email in Outlook, you don't want to leave Outlook to send the email. You want to do it in your native, whatever client you're using. And some of the solutions out there force you to go into some other type of either web-based interface that's outside of how they normally do it. But ShareFile is a great solution, and Mimecast, which does spam and antivirus filtering, is also a great solution for that.
Peter, is texting safer than regular email in this regard?
Texting is the same scenario. So texting is unsecure. There are some third-party texting packages that are used for encrypted texting, but your basic texting packages are not secure.
Let me make a comment about text messages. I've actually added to, I believe, even my retainer agreement that we will not respond to text messages, and text messaging should not be used or will not be responsible for it. The problems with text messaging, my whole life revolves around email. Or any faxes come through email, phone messages. We use a subscription for my cell phone, which I use for business, which I think many do, called Phone Tag. So I get an email transcription of every phone message. Our office system sends me an email transcribing automatically every phone message. So everything comes centrally through my email, and it's very easy to miss a text. Another problem with the text is I don't know how to save, and I'm sure there's a way to do it. I just probably have to ask my kids or grandkids how to save a text into the system, but it's certainly not as routine as saving an email. So when a client sends me a text, I always respond and say, please email or call, don't use texting, and we have a comment to that effect in our retainer agreement. I would be concerned if a client sends you a text and it's kind of off radar, that if a practitioner misses it, it could be a problem, or if you need to save it because it's an important piece of communication, how do you really save it? So be cautious with text messages, and I've kind of opted to tell clients that I'm not going to assume responsibility for them. That's not how I'm willing to communicate, and I'm certainly readily available because I print my cell phone on my letterhead, my website, every place else, and make myself available. But texting is not something that I feel is appropriate. And everyone may choose to handle that differently, but just a few thoughts. Now, there's lots of ways that we can meet the obligations of communicating with clients. And what I try to do, and again, I think Jonathan raised the question of how it's different in a larger versus a small firm, and Peter made the practical comment that it's easier to be more nimble in a small firm. So I don't know that what I'm going to suggest works for all firms, but I'm always trying to find ways to vary time and cost, but time as well, cost effectively communicate with clients. So one of the things that I've done, and it's in the first handout that's posted on the taskbar, is I use my billing system not just to bill, but to communicate. And I do that in two different ways. In the billing system that we use, and I would think any billing system could do this, it's really not a big deal, I post standard footers. So there's a number of general footers that I post on the bottom of every bill that inform people about things like what we just talked about with text messaging, what we've done in terms of cloud-based storage, so nobody can say that we didn't inform them. If they have a complaint on the bill, I expect to have a response in 30 days. Or maybe perhaps it's going to be interpreted as an account stated. We put a lot of that information on the bottom of the bills, in addition to perhaps having it even in more detail in the retainer agreement. The other thing that I use billing for, and you'll see the sample that I used in April in the materials, is I use it to communicate changes in the law. So if something new is developed, or I just start to see a pattern of things that is being overlooked by clients, I'll put a footer on a bill, and sometimes I'll only leave it for 1 month. Sometimes I'll have it for several months, recognizing that not every client gets a bill every month. But over the course of a year, my thought is that many clients, a large proportion of clients, will get a bill that will have some of those footers to inform them. And if it's an active matter, it's a great way to let somebody know. So, for example, when the 2704 regs came out and were proposed, I immediately added a footer explaining why they could be a concern if they were going to be finalized, which obviously they weren't, and they may never see daylight again. But I immediately put a footer for many months in the bottom of my bills, so that any active client matter, any client getting a bill couldn't say they weren't informed about the issue of these regulations. I believe what I also did, because it was simply too long to mail out, Jonathan and I did a pretty extensive, I think about 30-page ebook or report on 2704. What a waste of time that proved to be. but I made it known to clients that if they wanted a copy, if they would let us know, we'd be happy to send it out to them. But again, I use the billing system as a footer. Very negligible cost. It takes 15 minutes a month to set a new series of footers if there's a new development of law. With Trump's election in November, I immediately put a footer about his proposal of repealing estate tax. I practice in New Jersey, which not so long ago changed its exemption and as of next year repealed its estate tax, although no one seems to think that's going to ever stick. But I've disclosed that as well. I've seen issues with clients not administering trust, not addressing, for example, the insurance policy crisis where so many ILIT-owned policies are underfunded. So I may put that in for a series of months. Just a great way to communicate. And the final thing, the third component of that
Marty,
is,
let me interfere here and kind of interrupt a little bit on this. Do you think that, if you're telling your clients about certain changes in the law, and then you don't tell them about other changes in the law, that you're opening yourself up to criticism or at least unhappiness? Do you cover that in your engagement letter, or do you have that on the footer itself that, this is just something we're telling you, we're not going to regularly tell you about everything that might happen in the world that might affect you?
I see the point. We actually do have language in our retainer agreement that we can't and don't commit to inform everybody about everything, and I don't think anyone can expect that. But I think in the bigger picture, I'd far rather disclose to all current clients some of the bigger issues that are going on that may affect them than not do it. So my belief is that letting people know in a succinct form that there's some issues out there so that they're aware of it is far preferable to not doing it. So point taken, but again, I try to communicate. And the final and third point of what I do is every time we send out a bill, and there's a fascinating book called Nudge. If you haven't read it, you should. It'll tell you why we all bought Cracker Jacks to get that cheap little prize in it. But one of the many messages out of that book is to give something to people for free, to just sort of change the perception of what you're giving. So every time we send a bill, we also enclose some free articles on planning ideas that supplement or complement or add to whatever the footers are that we've just mentioned. And we mention those in the footer in the bill, so we have a record of what everyone's gotten. So over the course of a year, if an ongoing client has gotten a bill every month, they'll have also gotten at least probably 16 different articles, as well as the information in the footers. So that too addresses Jonathan's comment. When we look at how we can communicate, again, technology can make it really cost efficient to do. The webinar we're doing now, once you have a subscription, there's no incremental cost to doing it. Doing webinars and making them available to clients, newsletter blasts, email newsletters. I tried to survey the firm when we did the public presentation, the in-person presentation of this, and my impression, though it wasn't possible to really confirm it, was that more of the big firms had routine policies of sending out emails. Many of the smaller practices did not. Given the really inexpensive cost of email blasts and email newsletters, it's certainly something that I think everyone should do. And then, apropos to Jonathan's comment, I think it's the collective of all that is how we communicate with clients. So if I'm notifying clients about certain matters in footers, different matters in an email newsletter, I think over the course of a year, we're sending out a lot of information to help clients. And I had a client in yesterday who was talking about it, and it was interesting what her response was. Smaller estate, so she said she basically tuned out any of the technical articles and materials I sent because she knew they didn't apply to her because she doesn't have great tax issues. But the other articles that are relevant, she reads, and she said if they were really relevant, she would print them or copy them and put them in a file to have for her children if something should happen. So again, lots of ways we can all use technology to meet our ethical obligations, communicate with lawyers. And frankly, it's not just meeting our ethical obligations. I think there's tremendous marketing benefits to doing this. I think clients greatly appreciate getting free information. What else can we give them that when we're not charging them? Our ethical obligations are to explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Well, one of the ways that technology can help us meet that ethical obligation, and I'm going to let Jonathan comment to this, is if you use a document generation software for drafting documents, that software can also automatically generate summaries of documents that you've drafted, as well as covering letters and so on. So it's a great way to provide more bite-sized communications to clients. Jonathan, perhaps you may want to comment on that.
Yeah, Marty, there's no question that you've got to get into the modern world and using some sort of document assembly type system. As Marty indicated, I draft one with Mike Graham and some other lawyers, including Teresa Bush, who introduced us today. And many of those have automatic summaries, which you can change. In fact, I typically spent more time changing the summary than I did the document itself. But you've got to be into it. Well, one of my partners at Milbank Tweed, Fran Musselman, who was also the trustee in bankruptcy for Finley Cumble, the big law firm in Manhattan that went under, Fran is really the father of word processing itself. He went ahead and just nagged IBM to the point where it began to do it. And in 1986, I asked Fran to do a presentation before 500 lawyers at the Association of the Bar of the City of New York, telling them that they had to adopt this new technology rather than relying on just an electric typewriter. And I got several angry letters from people basically saying my secretary and I will continue to use the IBM electric typewriter until the cows come home. But as Fran said, if you didn't adopt that kind of technology back by the end of the 1980s, you were no longer going to be able to compete in practice. That's the same thing true with the document generation system. And let me say, and I don't do this to try to get you to adopt my system necessarily, but the cost of getting your own system done is extraordinarily high. One firm in Philadelphia 15 years ago, just to get its will done and a life insurance trust done, spent $250,000 and outside basically help to get those documents, the ones they wanted. Now, the practitioners always say to me, my clients love my language. That's simply not true. Your clients don't give a rat's patootie about your language. What they want is a competently prepared, efficient, and as low cost as possible document. They don't care your particular wording. Nobody on the phone, nobody holds the trademark to the word in trust or in trust nevertheless. It's just that everybody borrows from everybody else. You have to do it the best way you can for your clients. That's what it's really all about. So if you're going to do something, try to get one that has been used by other people. Some of these you can change if you really feel strongly about it, but it's going to make you much more competitive, be able, most importantly, to be able to deliver your documents more quickly to your clients. The biggest complaint about lawyers, believe it or not, are not the bills. It's the procrastination that the clients perceive. So, you know, Marty, that's my views on it, and I feel very strongly about it.
So a couple of quick comments. And again, I don't want to belabor document drafting software because it's only a tiny component of our program, but it's transformed how I view practice and how I practice. I did a wrap-up lecture for Heckerling a few years ago, and the topic they gave me was to talk about technology and practice. And one of the things that I had done to prepare for that is I had a client that had been in 10 years before, and then two years ago just before I'd done this lecture, and I got out the old bills, which we could generate from our billing system from 10 years earlier, and unfortunately the client hadn't come back for 10 years, which wasn't great, and the bill from when they had just come back. The bills were almost about the same, and I was absolutely marveling at it because I felt to do work at, and I'm sure my billing rates are substantially higher than they were 10 years earlier, but to do work for about the same cost and redo all the documents from scratch for the same cost as 10 years earlier, it was incredible. And this, by the way, is going to lead to some comments on billing, which we're going to come to in a minute. But when I looked at the underlying billing records, it was even more fascinating. 10 years earlier, when the client had come in and we were using word processing, as we all did, and drafting our own documents using our own forms and templates, I estimated about 70% of the time was junior associate drafting, senior associate reviewing, me reviewing, back to junior, back to senior, back and forth. The more recent bill, it was 70% was either me drafting a memo, meaning putting in thoughts and ideas to help the client, or sitting in front of the client, FaceTime with the client. It completely flipped the relationship of how much time was spent in front of and communicating and thinking for the client versus drafting. And I think that's really the heart of the future of all of our profession, because as we get more and more commoditized and people can go to LegalZoom and get a document, what is it that we offer? Well, we offer the ability to think. We offer the ability to collaborate with colleagues, with the wealth manager, with the accountant, and give clients things they can't get from just getting a document. So I think that it's not just a question of using document generation software. That alone is not even enough. It's letting the power of how it can transform our practices really happen. Web meetings is another way to communicate. I find it's an incredibly cost-efficient way to review documents. I won't do a web meeting. I try never to do a web meeting for the first meeting, because I find that the in-person human contact is critical to get a feel for the client. But when I'm reviewing documents, I find I can review the documents in about half the time on a web meeting than I can in person, because you don't have all the hi, how are you, you want a cup of coffee. You jump in, you show the document, the client's focused on their computer screen, let's say sitting at their kitchen table and looking at the page of the document you're focusing them on. So I find a web meeting is incredibly efficient. The conference that I did with Jonathan and Peter a couple months ago, less than half of the people seemed to use web meetings. I also found that very few of the advisors and colleagues that I spoke to, even fewer, used it for communicating with colleagues. I find that if, in terms of collaboration, if I can get the accountant, wealth manager, insurance consultant, whoever's relevant on a web meeting, 20 to 30 minutes, we can run through a planning memo in some cases, sometimes obviously on a complex matter much longer. But for a typical client, you can get an incredibly efficient a collaborative team going for very little extra money to the client, simply using a web meeting. We talked already about marketing tools. I personally use MailChimp to send out email blasts. It's inexpensive, it's efficient, it's a great way to communicate. I am about to try to differentiate a client versus a professional database so that I can do things that are more client appropriate. But there's so many ways technology can not only help us communicate, and the communication really becomes marketing as well. And I'm not sure why many of us seem to feel uncomfortable with the idea of marketing, but marketing by disseminating good information, to me, is really the most professional way possible to market. What could be more professional and more helpful, not only to clients, but to anyone who's receiving it, than to send out a newsletter or an article or a webinar and give free information. And technology permits us to do this inexpensively.
Right. One of the things is that, and Marty does it, you really should put on these communications that this may constitute attorney advertising. Some of the bars require that. so that, the attorney sends it out. Maybe you're doing it for the good of the nation, the good of the community, but it helps you build business. So almost all bar groups that have looked into this issue said it's a form of attorney advertising, and you need to put that on the communication. I think if it's an individual letter to a client, like the 2704 regs that Marty talked about, you're writing a client because she's gotten into such a transaction or maybe going into it, that's not the kind of thing. But it's like Marty said, a newsletter or something that's a mass mailing. Just, put a footer down there that this may constitute attorney advertising to protect yourself just in the event that somebody wants to give you a hard time about it.
And again, I think technology has transformed what we can do. I've never had a client complain by getting too much free information about what is relevant. I think it's a great way as professionals in such an incredibly uncertain environment. It seems uncertainty is the constant that we all have in estate planning. So sending out regular emails, newsletters, articles, I think is a great way to keep clients informed. I think they appreciate it. I think it's very protective to us as practitioners, because it'll make it much harder for someone to, in the worst case, say that they weren't informed of a change. But in the better case, it keeps clients knowing that we're thinking about it. And practitioners are always thinking about this. We all have to. So why not use the technology to just communicate what we've already done? Let's change gears real quick and talk about email retention policies.
I just want to say one thing about MailChimp and other types of mass email packages is they have the ability to know if the person opened up the email. So, for example, if you send something out to, let's say, 100 people or 200 people, there are statistics that you can access to tell you how many people opened it up and who actually opened up that email. So if somebody says, I never received it, you could actually go back into MailChimp, and there's some other packages out there, and determine whether they actually opened up the email or not. Whether they read it or not, that's a different question.
That's all correct. I have not chosen to use those resources to determine if clients are reading what I send. I feel from the standpoint of letting them know that I'm giving them free information, and from the standpoint of protecting myself from meeting any obligation anyone might infer, and I'm not even suggesting there is an obligation to keep clients current, that the mere sending of it should suffice. It's interesting, though, for example, webinars like this, what I find when Jonathan and I have done webinars before, when we do a webinar on a technical topic, the very data that Peter is mentioning, I do look at. So if Jonathan and I did a program on 2704, we would have had 3 times the registrants as we would have on a program like this, which is more of a fuzzy topic. You can see the actual correlation. So the data is out there, and it's quite interesting. Let's change gears, because we have a lot more I still want to get through in the time that we have, and talk about email retention. I was struggling to figure out what type of email retention policy that I wanted. One of the problems with retaining documents today is because we view electronic storage, and you'll see comments about this all the time, in contrast to paper storage, electronic storage is virtually for free. It's free, it doesn't cost anything. And that's really not quite true. It's not true because if a client calls and has a question, and you have, 80 documents, 100 documents come up when you search in your document management system, with some fairly narrow criteria, you got to spend the time going through all that. So one of the things that I try to do is find ways within reason to save things that are relevant, but not oversave to the point where it becomes costly to the client and inefficient for me as a practitioner to have excessive data. Very difficult to really know how to draw the line. And when I was trying to figure out what made sense as an email retention policy, I talked to a lot of different practitioners of lots of different size firms and got a wide variety of results. I was actually kind of shocked at some very smart, well-known practitioners who shall remain nameless, who really were clueless as to what their own email retention policies were. I think every practitioner should know what's going on in their own firm. I found that on one end of the spectrum, some practitioners save every single email that comes into their office, every single email. I don't know how you could get through the volume of data, but that I understand the concept. This way you have a rule, everything's saved, it's there, you can find it. Another approach, which is the one that I've opted for myself, and it's certainly not perfect, and there's lots of reasons, pros and cons, to do different variants, is we save emails that we legally deem relevant into the client file. After 90 days, everything is deleted. My concern is that if I have every single email saved for a client, and everyone on the call has seen this, where you can have a simple communication that results in 15 emails back and forth just because emails don't take a lot of time. In the old days where you have to have a letter typed and somebody print it, and you had to physically sign it, people were much more thoughtful about what went into a communication and how many they sent, because it took time and effort. So I've opted to simply use my legal judgment, and I think the ethics rules certainly support this, to save relevant documents in a client file, and after 90 days have everything deleted. I don't know if Jonathan or Peter, if you want to comment.
So my only comment on email retention is that, particularly when I'm talking with law firms, they're very hesitant to delete anything, which is dangerous. But some of the firms that we work with, for example, there's a not-for-profit, but they deal with legal subjects, and they just have a sort of a broad 10-year policy. Anything after 10 years, they delete automatically. And if there's anything that they need to save, they sort of move it to a saved folder. So that sort of takes care of their compliance. But a lot of firms are very hesitant to delete anything.
There are two other points that might be mentioned. One is that certain email providers, such as Hotmail, unless you pay extra or put it in a file, they will actually delete your emails after a certain period of time. Also, if you change the provider of the email service, you go, for example, from Hotmail to Gmail or whatever it is, you may find that not everything moves over flawlessly. So you need to make sure that if you're making a change, adopting a new system, that your records, to the extent you want them retained, in fact, will be retained.
So on page 21 is something I swiped from one of the large firms that I work with that I have great respect for, and to what they do with it. Let's go on, because we're going to come back to some of the points both Jonathan and Peter just made in context of general document retention, and why something that estate planners do may be different for us than others. Client property. So we have an ethical obligation to retain client property. We can't destroy client property. What is client property? Well, an original will, for example, is client property. Another thing that we talk about is file destruction. I want to take both of these concepts, client property and file destruction, and talk about them in the context of an electronic paperless office, and in the context specifically relevant to all of us on this call of estate planning. So in general, there's this concept that you can destroy files after 7 years, some say 10 years. I've seen in some engagement letters where firms will provide that they can destroy documents after a 5-year period. What's interesting, and this is, again, another large firm that I have great respect for. Oops, sorry about that, everybody. Respect for, if you take a look at the bottom of page 24, the second to last bullet point, unless otherwise specified by the billing partner, destruction date equal to 10 years from the date of the matter is designated closed will be assigned to all files with the following exceptions. Exceptions: estate planning, estate administration. Those will be permanently retained. So one large firm I have great respect for, they retain indefinitely all estate planning and administration documents. I think one of the things that we need to keep in mind is a lot of the ethical rules were developed at a time period where all records were paper, and it was not only costly to retain them, but every year you practice, that cost would continue to go up as you had to get more and more physical space to retain those dead storage boxes, and the cost of retrieving them was not insignificant. Do those same concepts apply in a paperless electronic environment where the cost we've kind of already talked about may be negligible to almost insignificant or non-existent, no incremental cost to retaining an additional record? Estate planning is different than what law generally is about, in the sense that if you have an estate tax return, what is the shelf life of that estate tax return? Well, that establishes tax basis until every asset that's been owned is sold. What is the shelf life of a will? Well, until a new will is done, that old will is the governing document. And even having an electronic copy of a prior will, if you need to show a pattern of a client's dispositive scheme, that may be relevant until not only after the client dies, but after any litigation following the client's death is resolved. So, what is the right time frame? And I've heard pros and cons on both ends of the spectrum. I've heard those from a litigation perspective suggest that perhaps the least you retain for the shortest period of time, the best approach to protect the lawyer. I've heard the exact opposite, that retain everything for as long as possible. So again, I think thoughts to consider. Now, one of the other points in this discussion is, what is now client property? What are client files? We have to turn over a client file if asked. Now, in the paperless environment, if I've given the client back all their original documents, will, trust, health proxy, so on and so forth, so I have no original documents, I have no client property. If I've given the client, because they've been a recipient of every significant email, memorandum, and letter, and they have all the original documents, what left constitutes a client's file? And why is that relevant? Well, one of the things that I'm seeing after 35 years of practice is we'll get calls from somebody that hasn't been a client in 20 years, and there's something going on and they want a copy of the client file, or there's litigation and they want a copy of the client file. Well, it takes time to go back even through electronic records and find the client file, organize the client file. Sometimes you really have to bait stamp it so you have a detailed record of what was given. That too takes time. So, shouldn't we be able to charge for that? We're not really turning over documents as we had in the past. I think in the past, we as lawyers had one of the important functions we served was sort of the keepers of the paper, because clients didn't have it. Well, now clients have the same basically free electronic storage we do, and we've transmitted the files to them. So I think a lot of these issues need to be rethought. What we have done is we've reserved the right after 7 years to destroy everything. We have not destroyed anything on the theory that it's a service to the clients to have these records should something happen. And I've recently added to our retainer agreement that if we're going to go back and provide copies of client files, electronic copies, we're going to bill for it, because I've had just an unfair number of requests of people asking for it, and we've already spent the time to return all our original documents. Jonathan or Peter, any comments, thoughts?
Yeah, I want to make a couple of things. One is to say it's going to be kept forever is just not realistic. I mean, maybe people will wind up living for hundreds of years, but I certainly think, you could put something like for 50 years or 100 years, so it doesn't have to be forever. The other thing that you ought to have an exception is if the client changes attorneys and wants those files transmitted, then, we will no longer retain those files. That's maybe something that should be added. You could do it when you transmit it, even though we've said we're going to retain these records forever because you've asked for them or you've asked them to go to your new attorney. We will no longer retain them. Just to make a blanket statement, we're going to retain them forever and ever and ever, I think it is a little bit dangerous if it arises, say, in 25 years, and you just have no reason to keep it any longer.
If I implied that I put in writing that I retain things forever, I don't. We have in our retainer agreement that we can destroy anything in our discretion after 7 years. We've chosen not to. Part of the reason also not to is to the time it takes to go back.
Right. It was a statement, if you go back one slide, Marty, that you got from that law firm, which said the files will be permanently retained.
Right.
And I just don't know whether you can say, forever and ever and ever. But you can also say we, as a general matter, will destroy things in 10 years, but then the firm can make a decision as to what it wants to keep. I mean, for example, if the client has died and the will has been admitted to probate, it's gone through the entire process, things have been transmitted, maybe 5 years after that, getting rid of prior wills, even if you retain the originals of prior wills, it would be safe to destroy them. I don't think that really violates anything or is bad to the client, but maybe you give them to the executor at that point. And of course, as we know in states, you can pay to have files filed in the courthouse.
I think the key point is technology is transforming how we view all of this. A lot of the ethics rules were created initially at a time when what files were was very different than what files are today. And I just think we all need to give more thought to what really works. I don't really think I have anything close to perfect answers. I'm spending time thinking about these issues because I'm trying to find what's the best way to run my practice, protect my clients, and also protect me. And again, I just think it all needs to be rethought in light of the new environment, and a lot of the ethics rules are barely keeping up with what the technology has done. Let's do another couple topics before we run out of time. Personal laptops. So my guess would be many, if not most, if not all practitioners sometimes work on their personal laptop. Now, much of my work, I may go into a portal. I use GoToMyPC and work through my office. But sometimes, especially if I'm offline, I may work on a personal laptop. I don't want an issue of that laptop being viewed in a litigation context as a business laptop because it's my personal laptop with all my personal information on it. I'm also concerned about not having information that's client-based on a personal laptop and not getting it into the firm document management system so that it's properly stored. So what our policy is if somebody works on a personal laptop, it gets saved. That document has to get resaved really as quickly as possible into the firm document management system. And if it's a personal laptop, we characterize it as such in a tech manual that we have, so that we know what computers are business, what are personal, and we make a concerted effort to get the stuff where it has to be. I really don't want to find that client-sensitive documents have been left on a personal laptop and not backed up. Again, just something that I think each firm will have to establish its own policies. And I think, apropos to Jonathan's comments and Peter's comments about some of the differences from large to small firms, the policies may differ, but I think we all need to have policies addressing this. I surveyed the audience at the program Jonathan and I did, and again, comments were all across the board. And it seemed that for the most part, in terms of estate planners, people did retain files for a pretty long period of time. We've talked about what's client property and record retention, so let's skip that. We've talked about the client file, and again, the key point I was trying to make is historically what had constituted a client file that we have to turn over, it's quite different now because clients really already have the file. I've started to indicate in our retainer agreement that we give clients copies of all memos, letters, emails, et cetera, and documents, and they have the whole file. And again, the concern that I have is just the cost of complying with excessive requests for providing files years and decades down the road. Cloud storage, certainly permitted. We talked about the new ethics rule earlier. What steps, Peter, might we want to take as practitioners to confirm that the cloud-based storage is secure? How do we know?
So what you want to do is make sure that the storage is encrypted at rest. The next thing is your ability to log into the cloud storage. You want to use something called two-factor authentication, which is the same as if you're going onto your banking site and you put in your username and password, and they'll either send you an email or a text message or some other method of communicating to you, and then you would put that secondary method in there. Now, if you're in a safe place, meaning your office, so that's considered a safe place, a lot of two-factor authentication is not necessary because you're in a trusted zone. But if you're working remotely, that's where you want to enable something like two-factor authentication.
One of the issues we all face as practitioners is the ethics opinions, including the new one that we covered earlier in this not so recent New York bar opinion. They use phrases like reasonable care, reasonable steps, and you know, the concern is what is reasonable? How does that change as the technology changes? You know, how is reasonable going to be interpreted until we really know what's happening? Client confidentiality, we have to maintain confidentiality of client information unless the client consents. Just very quickly, because we're getting near the end of time, we've talked about using encrypted email like ShareFile and some of the other software that Peter mentioned for transmitting documents with tax ID numbers or other sensitive information. I'm surprised many of the firms that I've worked with and visited don't have even alarm systems in their offices. I don't know why. I think to protect the physical environment is important. Encryptions, passwords. Peter, maybe you could make some general comments about some of the bigger mistakes or areas of improvement you could see for firms to make in terms of encryption, password protection, and so on and so forth.
Yeah, so the main thing you want to do is protect users from themselves. I mean, that's how I see it. So if you use like an email system like an Office 365, you can enable things like data loss prevention policies that will prohibit anybody from sending out information such as credit card information, social security number, and other types of personal information. That's one thing. And the other thing is for particularly attorneys and you and staff, you want to enable or do some sort of cyber security training. So sort of the do's and don'ts of how to handle sensitive information. If they get a particular email from a bank, how to verify that email is from that bank and not from somebody trying to spoof that bank. So these are things that a firm, I'm giving you a very quick synopsis, but these are some of the things a firm can do to protect themselves.
And again, the fact that you've had training or that you documented a consultation with your IT professional, doesn't that go to corroborate that you've taken reasonable steps? So the detailed bill from your IT consultant saying that you've consulted with the firm on these issues is part of corroborating that you've met the standards of the ethics rules. So I think that's a practical way we can address some of the vagueness of some of these ethics rules. We're out of time, but if everybody can continue for just 5 minutes more, I think we'll wrap up the rest of the program. We're almost done. Another issue with attorney-client privilege is what happens in terms of representing clients with incapacity. What happens in terms of collaboration? I think the estate planning world has changed. I'll make a quick comment on this and then see if Jonathan has anything to add. But the estate planning world has changed. 10 years ago, it may not have been nearly as critical for an estate planning attorney to collaborate with the wealth manager, with the insurance consultant, with the accountant. But 10 years ago, when with $1 million exemption and anybody walked in our office, and we were doing much more tax-oriented planning, there may have been less of an incentive or less of a need for the client's benefit to collaborate. I think the planning has grown ever more complex on the higher end estates, and I think for all levels of wealth, the issues of planning for aging, longevity, minimizing elder financial abuse, and so on, you almost can't do the best job for the client without collaboration. But collaboration then brings into play questions about privilege, and if we as attorneys are sending certain information to the accountant or the wealth manager, how does that affect privilege? If we're dealing with an aging client base and we need to communicate with the client's agent under a power of attorney or successor trustee under Rev Trust, do we have the authority to do that? So one of the things that I've done in my practice is I have clients authorize us to deal with and interact with other advisors to the extent we feel necessary and acknowledge that it may impact the attorney-client privilege and so on. Jonathan, do you want to make any comments on this topic?
Yeah, Marty, I think you're absolutely correct. The focus for such a long time was on avoiding estate and similar taxes. But nowadays, I think what clients are going to come to you, they're going to want help in 3 areas, which many of us, and I'm in that boat, did not really focus on primarily in representing even well-to-do people. One is making sure that they plan for their and their spouses and possibly their descendants' disability. That's a huge thing. Marty has pointed out that if you have a couple who are 65, there's a 70% chance that at least one of them will have a cognitive impairment during their lifetime. And you really need to begin to prepare for that now. Are you going to use just a durable power of attorney? You're going to use a rev trust? What else are you going to do? You're going to want to have healthcare proxies, certainly a living will, but that's something where you're going to have to probably coordinate with other people, some of whom will be in the medical field. In addition, your clients are going to expect you to plan with them for their retirement. And that's a very complicated matter, especially for people who don't have uber wealth, because they have to decide with you and possibly with their accountant, and believe it or not, especially with their insurance advisor, what they're going to do. One of the trends that's occurring right now is rather than dividing your assets into, say, 50% stocks and 50% fixed income, well, the fixed income is never going to grow. And in fact, if you have to start eating into principal may disappear, even the stocks may disappear, is to possibly get an annuity for life. And there are annuities for life that actually are inflation adjusted. Well, you know, the lawyer needs to work certainly with someone who's very, very bright in annuity, which means you're now into the insurance area. So you need that. And finally, of course, you need to think about the transmission of and the protection of wealth. So you're now into at least fundamental parts of estate planning, such as using trust for the surviving spouse and for the children. Very, very important, with a much greater emphasis than at least I used to give when I was focusing almost exclusively on reducing estate taxes, which of course, when I got out of law school, 80% of someone's wealth could be eroded by estate taxes. That's obviously no longer true. And the more important point is that for only 3 out of 1,000 Americans are going to have at least a federal estate tax problem. And even in a state like New Jersey, it's going away. In New York, it's essentially going to have the exemption go up to the federal. So again, the emphasis is not so much on estate taxes anymore, although that's still important for the uber-rich client, but for those other 3 areas I mentioned.
One of the things that I do is we have an intake sheet signed by clients even before I go into a meeting. And one of the segments, there's 3-4 different segments in that, is having the client give us the name and phone number for each of their other advisors, insurance, wealth manager, trust officer, general attorney, accountant, and so on, and authorizing us to communicate with them. And there's some more information in the slides and a sample clause for a power of attorney to address that issue. Let's talk, and then we'll wrap up on billing and technology. So one of the things that's changed, technology changes how we bill. I've talked a little bit about how I use billing as a form of communication for clients as well. But if you adopt document generation software, something that may have taken 20 hours or 30 hours or 40 hours to do 5 years ago, you may now do in a couple of hours. How do you bill for that? And I think that that's an issue, and I tried again polling the audience at some of the seminars I've done, and I'm not sure if people are comfortable talking about it in public or just don't want to address it, but I think it's something we all need to rethink. Some aspects of technology, I think, make it unfair to us as practitioners to bill hourly. What I've done is I've instituted what I call document charges or drafting charges, because if I invested a huge amount of time in adopting technologies to be able to work more efficiently, if I'm now only billing hourly, it makes the cost of doing a complex irrevocable trust unfair to me for the time, thought, knowledge, and background that goes into it. I think this is something that we're all going to deal with more and more as time goes on, and technology transforms how we practice. Jonathan, any comments on that?
No, Marty, I think you're exactly right on the money on that.
Okay. Final comment. Technology has also changed the process of vetting clients. There was actually a lecture, excellent lecture at one of the breakout sessions at Heckerling this year, and they used a term I had not heard of before called pre-engagement. And I don't know how prevalent it is, but we've hopefully are doing it now routinely in my office, when a prospective new client comes in, or frankly, a returning client, we have somebody in the administrative staff do some internet searches to see what information comes up on the client, on any business or professional practice names of the client, so that at least we have an idea what's out there. Certainly if we're going to do any meaningful asset protection planning or wealth transfers, we're going to get something much more substantial in terms of lien and judgment searches and maybe even something much deeper than that. But before somebody walks in the door, it's incredible the information you can find in 15 minutes just with some general online searches. And in many cases, we've come up with boring stuff, nothing of note, but in a number of cases, we've been quite alarmed by some of what I've heard people refer to as reputational risk issues that have raised some red flags that make it us very careful with what we're willing to do for that client until those issues are addressed. One client, I found some really horrific stuff on the Better Business Bureau in terms of complaints and problems with the client. And before I accepted the client, I actually confronted them and asked them to address it, and they did, and very satisfactorily, and we move forward. But I think that's something we also need to rethink, because how can you say, no, I didn't have any idea that this person had all these complaints against them? Jonathan?
Well, that's true. Also, you may get some good information. For example, in your search, you may find out that that person owns a piece of property in another state, and it maybe have held so long ago because it's unproductive that you need to take that into account in preparing the estate plan. In addition, you may find a record that the person has been divorced, or, as Marty said, there's a lawsuit against them or a judgment outstanding. Not that they're trying to hide it, but again, we've all got to be sensitive to this stuff. But there's a tremendous amount that you can get from the internet, which will help you actually inform the client of what needs to be done. So it's not just protecting you from taking on, John Gotti as a client or Bernie Madoff as a client, but it also will help you in basically, filling things out. For example, you may discover that the client has a disabled child or a disabled brother or something like that, which you then can raise with the client, or just say, do you have anyone in the family who is suffering from a disability? And he says, yes, my brother. Well, do you feel you need to help that person at least financially in your plans? So Marty's right. Doing those searches is extremely important.
And again, it's just another illustration of very simply and not much from a cost perspective, how technology is transforming how we practice. When I did ask audiences when I've lectured on this, I have found that very few attorneys seem to be doing this, and most continue to just use their gut feel based on a phone call or introductory meeting. One of the things I've also done, and it's not tech related, I want to hear from a secretary or receptionist their reactions to new clients. I always, if there's any concern at all, I have them give me a note or verbally tell me, because I find that many clients will show their true disposition or character to a receptionist by being really crude, inappropriate, rude, or worse, but they won't do it when they're talking to an attorney. So just another comment. To conclude, I think technology has and will continue to transform how we practice. I've tried to share with you some of what I've done in my practice, and I am grateful for Jonathan, who's really put me on this path many years ago, and to Peter, who keeps me out of trouble on this path for some of their insights and comments on technology and estate planning. I think the transformations are going to continue. I find it exciting. I find it liberating. I feel that every time we adapt new technology, it helps me do a better job, more cost effectively, and that's great. That's exciting. Jonathan, any final comments, and then we'll have from Peter.
No, Marty, you were a great conductor here, at least from my perspective. I think Peter would tend to agree to that, and I hope people will find it very informative, and even more important, I hope it will help them in adjusting their practices in the future. And the changes we've seen over the last 20 years have been significant, but I think they'll even be greater over the next 5 years on the kind of technological changes we see and how we have to react to that.
Peter, any last comments or thoughts?
Yes. Yeah. Sure. Thank you, Marty, for allowing me to present. But I just want to say that, the technology is getting more and more sophisticated, and the cost to implement these type of technologies, where it would have cost $20, $30, $40, $50,000, are now, an affordable, $4 per month per user, or $10 per month. Everything is software as a service now, and security as a service, and everybody should be computing in a safe manner. Protect your data, protect your clients' data when they send it to you, and think about what you're clicking on before opening up an email or attachment or whatever, and you'll be a whole lot better.
Thank you, everybody, for joining us. A recording of this will be posted on Schenkman Law, and perhaps Interactive Legal will be able to post a recording as well. If you have any comments or suggestions, all of the email addresses are on slide 55 and on the screen now. Please feel free to email us questions, comments, or thoughts. And again, thank you for joining us, and thank you to Interactive Legal and Peak Trust for helping sponsor and promote the program. Jonathan and Peter, thank you for your time and your help. Bye, everybody.
Thank you. Bye-bye.